Well, good afternoon, everyone. I'm Bill Traynor, the Dean of Georgetown Law, and it's my pleasure to introduce our distinguished keynote speaker today, Chief Justice Hassan Jallow. Before I do that, I just want to say, this is really an extraordinary program, and I think all of us at Georgetown realize that, at this moment in history, the focus on global criminal justice is so pressing. And to have these panelists and to have all of you in the audience be part of this discussion is remarkably important. So I want to thank everybody who's here for being here today. Now this morning you heard from Professor Andrew Schoenholtz about the legacy of Professor Sam Dash. So this is the Sam Dash Conference on Human Rights, and about how Professor Dash's commitment to protecting human rights continues to be a cornerstone of Georgetown's vision. So I think everybody of my generation, of course, knows Sam Dash. I think I was actually looking, as I was leaving my office this morning, I have on my shelf his book, Chief Counsel, from when he was counsel to the Senate Judiciary Committee during Watergate. And he really, as DA, as chief counsel, he was someone who was so committed to criminal justice, to constitutional government, and he had an extraordinary impact. He had an extraordinary impact on Georgetown law. I see in the first row Bob Muse, who's one of his former students, and I've heard from Bob and from so many of his students about the way Sam Dash inspired them and helped them realize what a legal career could involve and the difference it could make. So anybody who's familiar with American constitutional law, anybody who knows the history of Georgetown law, realizes what a profound debt we owe to Sam Dash. But perhaps his greatest legacy, is in the area of human rights. And that resonates for us. For those of you who don't know Georgetown law, our motto is law is but the means, justice is the end. And Sam Dash's career really embodied that. And in so many ways, his commitment to justice and his commitment to human rights made a profound difference to the world, and we honor him today. So, it's a privilege for me to be part of that. And very fittingly, our keynote speaker today embodies the same commitment to justice that Sam Dash had. So we're honored to welcome the Chief Justice as the keynote speaker at the 2017 Samuel Dash Conference on Human Rights. Chief Justice Jallow is a distinguished Gambian lawyer and jurist who was appointed in February of this year to serve as the Chief Justice of Gambia following the country's election in December. Upon appointing Mr. Jallow as the Chief Justice, newly elected President Adama Barrow noted that his local and international experience would, quote, take the Gambian justice system to higher heights. Indeed, his work before this important appointment is truly inspiring and should serve as a great example to our students who are here of the kind of justice that committed lawyers and jurists can pursue in the world and the difference they can make. You can read his full biography in the program, but as you'll see, he's held a series of positions of the greatest importance. Before his appointment as Chief Justice, he served as Chief Prosecutor of both the International Criminal Tribunal for Rwanda and the United States Mechanism for International Criminal Tribunals. In the Gambia, he served as Solicitor General, Attorney General, Minister of Justice, and as a judge of the Supreme Court. He's worked with the United Nations, the Organization of African Unity, and the Commonwealth. He studied law at the University of Dar es Salaam in Tanzania, the Nigerian Law School, and University College London, and he's published widely on issues of human rights and international criminal law. And we're just so fortunate to have him here today. So the Chief Justice will speak, and again, I'm so grateful. The Chief Justice came from Gambia to be here, which is really it's a testament to this conference. It's also a testament to the fact that, as he says, it's impossible to say no to Jane Stromseth. So the Chief Justice will deliver the keynote, and then Professor Stromseth. I have to teach, so I'm going to leave at this moment. I'll miss the pleasure of hearing your keynote, but I'm fortunately, we have a record of this and we're taping this, so I look forward to seeing it. The Chief Justice will deliver his keynote, and then he's agreed to take a few questions, and Professor Stromseth will call on people from the audience. So please join me in a big round of applause for the Chief Justice.
Thank you very much, Dean, for your kind words in introducing me to the conference. I'm particularly honored to have been invited to do the keynote address here, and I'm happy and honored to be here also. I'd like to thank Jane and the Dean for having arranged this, the organizers for putting together this meeting. I've listened to the first two panels, and I think it's been an excellent beginning to the program. And of course, I'm also delighted to see a lot of old familiar faces, many of them belonging to people who have, over the years, been very instrumental in shaping the global response to atrocity crimes all over the world. There are many of them here, and I'm delighted to take note of their presence. My colleague and friend, David Crane, David Schaeffer, Stephen Rapp, and several others. So it's a great pleasure to be here and to participate in this conference. On 26th of April 1995, Tadic, and I believe most of you would know him by now, he stood in the dock in the courtroom in The Hague, and he pleaded guilty to charges against him. This was not an ordinary national court. It was the dock of the International Criminal Tribunal for the former Yugoslavia. His plea was taken before an international court by international judges selected by the United Nations. And the charges were not violations of any national law, but they were violations of international law. It was a trial before an international court for international crimes created by international law. The event and the process that followed that particular day were not without precedent. We had Nuremberg much earlier, when on 21st November 1945, 22 accused persons, leaders of the defeated Nazi regime, although also pleaded not guilty to charges of conspiracy to wage aggressive war, of waging aggressive war, crimes against the peace, war crimes, and crimes against humanity. They too had pleaded not guilty, but an interval of half a century divides those two events. And it took, as you can see, half a century before the international community again ventured into international criminal prosecutions. Tadic's trial was a momentous occasion, one of great historical significance, not because of any facts, or not because of the law, but for the fact that it ushered in one of the greatest developments in the international arena this century, and it set in motion a process of international criminal accountability from which there now appears to be no turning back. Since then, of course, we've seen through the Security Council the establishment of the ad hoc tribunals for the ICTR in respect of the atrocities, the genocide in Rwanda in 1994. We've seen the establishment of hybrid tribunals by the UN and jointly with member states of the Special Court for Sierra Leone, whose first chief special prosecutor is here in the person of David Crane. And we've seen the establishment of the extraordinary chambers in the Court of Cambodia and the Special Tribunal for Lebanon. And there have been other experiments as well, particularly in the Africa region. We saw the just recently concluded hybrid trial, which was a creation of the African Union, which brought to account the former president of Chad after decades of running away from justice. Since Tajik's trial, we can say that the process of international criminal justice has remained uninterrupted, despite several challenges. Today, we are in the situation where there is a phasing out going on of the ad hoc tribunals. You know, the ICTR has closed down. The Special Court for Sierra Leone has also closed down, and both have now been succeeded by their respective residual mechanisms. The ICTY, I believe, by this year or early next year, would join the list of former tribunals, and the rest of its work will come under the residual mechanism. So it's an opportune moment now, really, for us, as we particularly move towards consolidation of the ICC. It's an opportune moment for us to take stock of the past, to examine how the gains so far can best be secured for the future, and to begin to develop responses to the challenges that lie ahead for global justice and accountability. And I think it's fair to say that the past 2 decades have been fairly successful in the global effort to ensure accountability for these crimes. And that the legacy, the legacy that the ICC and those engaged, who will be engaged in carrying the struggle forward, lies in the work of the previous tribunals in ensuring the accountability before courts of law of hundreds of senior level persons, perpetrators or planners of atrocity crimes, who because of their powers and because of their influence in the past would have escaped justice. The expansion of the frontiers of international law in all its spheres, the development of techniques in the very complex area of investigation and prosecution of international crimes, which provide us with good practices for the future, the encouragement of national limit of international criminal law, the contribution of these tribunals to reconciliation and restoration of the rule of law in the various communities where conflict had led to the intervention of international justice, and above all, the demonstration provided by the work of the past 2 decades that international criminal justice is a viable project. It's a necessary project if we do want peace and progress globally. Therein lie, I believe, the successes of the projects that we have been engaged in the past 2 decades. But there have been, and there continue to be, challenges as well. Many perpetrators continue to avoid justice because of the limited numbers that this international system can deal with. We can only prosecute a few, although a very significant few, who play a leading role in these crimes. And I believe from past experience, there is still room for more effective prosecution of sexual violence crimes in situations of conflict than we have been able to really achieve in the past 2 decades. Sometimes the courts have been, and the process has been criticized as being slow, too expensive. But again, we need to acknowledge that over time, there have been reforms, there have been changes, and the timeline and the costs for doing these cases is generally becoming less and less. The timeline for trials has been progressively reduced. International cooperation, which is the linchpin of the arrests and transfers of fugitives, has in some instances fallen below expected standards. We closed the ICTR with some fugitives still outstanding, partly due to the non-cooperation of certain states. Jurisdictional and capacity weaknesses in national systems have created gaps in the struggle against impunity, through which suspected perpetrators are working freely. The duty of states to prosecute or extradite in respect of mass crimes is increasingly in need of effective realization. The unanimity or consensus amongst the big powers, which actually made so much of this success possible, which made it so easy, I believe, to have started this project of establishing ad hoc tribunals and hybrid tribunals, is increasingly becoming difficult to obtain. So one of the great challenges we face is then how to ensure that the gains of the past in the administration of international criminal justice are effectively secured and made available for future practitioners. The areas of the substantive jurisprudence offer very little challenge. The judgments are reported. They are easily accessible to those who need them, the lawyers, the judges, the practitioners, etc. There are, however, numerous rulings on practice and procedure which need to be identified, to be assembled, to be digested and published to make them accessible to those who need them. The internal regulatory framework of the tribunals, their internal practices and procedures reflect, in my view, very good and relevant practices in the area, for instance, of case and trial management, in investigations, in prosecutions, witness management, etc., developed from practical experiences. These practices need to be harnessed, they need to be identified, as I said, compiled and made accessible, as well to the international practitioners, to the practitioners of international criminal justice. There has been a modest start in this area by the prosecutors jointly before we close down the ICTR, leading to the preparation of the compendium of manuals on best practices for the investigation and prosecution of international crimes. It was a general manual. What now requires to be done is to focus in greater detail on some specific aspects. And it's only in this way, I believe, that the lessons of the past, sometimes they're successes, sometimes they've been challenges, sometimes they've been failures, can be harnessed to good use for the future. A project like that would help us to avoid repeating the mistakes of the past, reinventing new wheels, and thus enable us to put good lessons, to put to good use the lessons. The killing of civilians, we know, has continued, unfortunately, on a massive scale in both international and non-international armed conflicts since the Second World War and the adoption of the Geneva Conventions and the protocols. We live in an era when the foundations of the laws of war, regulating the means of warfare and protecting civilians in terms of conflict, seem increasingly to be at risk. It is vital that the international community, that all of us insist that conflicting parties respect the obligations to protect civilians, that violators of this obligation are brought to account, and that the legal regime for ensuring such accountability should be reviewed and strengthened. The cooperation of states continues to be as essential as it is challenging. All systems of justice rely on state structures for their effective operation, and the international system is not an exception. A fundamental difference is that this international system which we are operating and which we want to secure for it to continue to operate depends almost entirely on the political structure and goodwill of states. A local national judge will issue subpoenas for witnesses, issue a warrant of arrest, order of commitment to prison, fully confident that the law enforcement structures of the state will normally execute these orders and ensure the arrest of the accused or suspect, ensure the appearance of the witness in court, and ensure the conveyance of the accused, now the convict, to a lawful place of detention or imprisonment. We do not have these assurances in the international system, and that is one of our difficulties. The International Court is bereft of this assurance, much as its orders and decisions may be legally binding on states, the court lacks a police force which will readily enforce its orders for the arrest of persons, for the production of witnesses and evidence, for the detention or imprisonment of persons, etc. All these actions, crucial as they are to the effectiveness of any system of criminal justice, will be carried out by national agencies only on the authorization of the political organs of the state whose cooperation is being sought. And essentially, the choice of state cooperation with international courts, although a binding legal obligation, is unfortunately largely dictated by the concerns of political arms of the states concerned. Admittedly, in the vast majority of states, in the vast majority of matters, states have made the right choice to support the mandates of the tribunals and to give effect to their requests and orders. Nonetheless, issues of cooperation remain in respect of the arrest of top-level fugitives, the transfer of convicts for imprisonment, relocation of acquitted persons, relocation of witnesses under risk, etc. And until now, even though the ICTR has closed down, it still has left a legacy of persons who still require relocation and who are still staying in Arusha, the former headquarters of the court. Now, they are under the jurisdiction of the mechanism. State cooperation is as much a strength as the Achilles heel of the system. Thus, while state cooperation, while dependence on it remains indispensable and it will continue, it is perhaps opportune to explore ways of not only ensuring that it is enhanced, but also perhaps making the machinery of justice as much as possible autonomous and less dependent on these individual states. Some starting points have been suggested. Create an international police force with adequate powers, establish an international prison for suspects and for convicts so that state tribunals don't have to be looking for places of detention anymore, seeking the consent of states. Too futuristic, perhaps, but I remember as far back as 1979, when we were meeting as a group of experts to draft the African Court of Human Rights Charter, one of the delegates actually went beyond and suggested that we should start thinking of a World Crimes Court. And everybody thought he was a little bit, you know. And of course, he's still alive, and we still like to talk about it and call him and say, well, you have the ICC. Perhaps too futuristic, but if we recognize that the international system is here to stay, and we do want it to be strong, and we do want to enhance state cooperation and lessen its dependence on states, we have to try and make it as autonomous as we can. But I think the biggest challenge the system faces now perhaps lies in the implementation of the principle of complementarity. The principal limitation of the system lies in the fact, as I mentioned earlier, that it cannot prosecute all offenders, that its reach is limited to a few. This limitation compelled the ad hoc tribunals to shift from a de jure status of concurrent jurisdiction with member states, but with primacy of the tribunals, to a de facto relationship of concurrence and partnership. Hence, the tribunals, that is the ICTY, the ICTR, etc., had to develop and prioritize strategies for the referral of cases to national jurisdictions. The transition in legal strategy from concurrence and primacy in the ad hocs to one of concurrence and complementarity under the Rome Statute is an acknowledgement of the limitation of the process of global criminal justice. Given this challenge, complementarity must be made effective in order, given the limitation, to ensure success in combating impunity. Weak complementarity, on the one hand, and an overstretched ICC potentially provide a huge gap in accountability for perpetrators to walk through. But complementarity is very often not readily found. it has in most cases to be created, and we must create it. Realizing complementarity requires a sustained national and international effort to empower national legal systems through, among other things, a process of law reform and capacity building to enable these systems play their roles in the prosecution of international crimes. It requires building the necessary political will in member states to ensure that no safe havens exist for perpetrators of crimes. National laws need to fully domesticate the elements of international crimes, the jurisprudence of the international courts, and the fair trial standards of the international system. And despite 2 decades of existence, it's surprising that much of this still has to be done. When we tried to transfer from the ICTR cases for trial in national jurisdictions, we had a few surprising discoveries. In Norway, for instance, as you may know, we discovered that the crime of genocide had not been domesticated. They had murder in their books, but no crime of genocide. And as a result, we could not send our cases there. We tried to go to France. We succeeded in going to France, sending cases to France, only to discover they had no experience whatsoever, or no capacity in dealing with these cases. There was no specialized system, specialized unit within the legal system of investigators, of judges, of trial attorneys to handle these kinds of cases. And that situation seems to prevail still in some other countries. Of course, both Norway and France took remedial measures. Norway amended its laws. France developed its capacity. But the other day I checked, for instance, how many countries had domesticated the Akeisu judgment delivered by the ICTR, providing a new definition of rape. And I believe only Costa Rica has done so globally. Only Costa Rica has actually changed its penal law to give this broader definition of the offense of rape. So we still have very serious gaps in ensuring that the national legal systems reflect the jurisprudence of the international tribunals. Apart from that, also the judges, the prosecutors, defense counsel, investigators, court administrators, and several others all require training to enable them acquire the specialized skills for the management of cases. It also requires the building of the necessary political will in states to ensure that no safe havens exist for perpetrators of crimes. The experience that the ICTR and the ICTY have developed in respect of capacity building for Rwanda, for instance, and also a law reform for Rwanda on the one hand, and also developing the legal systems of the former Yugoslavia on the other, I believe provides some good lessons for the ICC and others in trying to implement the principle of complementarity. But beyond that, we need also to be more elastic about the notion of complementarity, to stretch the principle beyond the national systems to embrace regional systems of law. The architecture of the machinery of justice needs to be reviewed and possibly restructured to bring in regional courts, not only national courts, within this structure of complementarity. Regional courts can play an effective role in the process of accountability. There has been considerable experience with regional judicial structures as part of the process of economic or political integration. We have the East African Court of Justice for the East African community, and at some point there was serious consideration being undertaken about extending its jurisdiction to cover international crimes. The European Court of Human Rights, the ECOWAS Court of Justice is carrying out similar studies. The Inter-American Court of Human Rights is there. The African Union has adopted a protocol, the Malabo Protocol, to extend the jurisdiction of the African Court of Justice to cover penal matters. It's yet to come into force. And I think all these regional judicial institutions are potentially very strong links in the chain of complementarity. The expansion of their jurisdiction to include prosecution of international crimes may greatly facilitate the struggle for accountability and help make complementarity a living reality. For the fact is, the kinds of offenses we deal with often leave national national legal system of the country concerned in tatters. After the genocide in Rwanda in 1994, there was hardly any legal system in place. Many of the judges, many of the lawyers had been killed. So it's difficult to talk of complementarity in that context. You have to go beyond that state, see whether there is a regional system around there with which that state is associated for that regional organization to be able to play a part in the prosecution of those crimes. Combating impunity and promoting accountability should be part of the process of regional integration, particularly where there are regional judicial institutions in place. A pooling of regional resources within a region could assist the member states collectively to address issues of challenge to them individually. And there's the additional advantage which regional courts have in common with national courts of proximity to the locus of the crimes and the possibility, therefore, of a more effective outreach to the communities affected by such mass atrocities. The African Union initiative in dealing with issues of accountability for past abuses in Chad through the Habre trial in Senegal is a good example of how a regional process can address such issues in a complementary manner, effectively and expeditiously. And similarly, we look forward to success for also the African Union in securing justice for the victims of mass atrocity in Sudan. You may be aware that the African Union has been considering establishing a special tribunal, a hybrid court, to deal with the crimes in South Sudan. And we also look forward to the entry into force of the Malabo Protocol for the expansion of the jurisdiction of the African Court. Ultimately, therefore, the system of international criminal justice may best be served by an architecture comprising a pyramid of judicial structures, at the base of which lie sufficiently empowered national legal systems, with regional judicial institutions at the intermediate stage, and at the apex, an ICC exercising its jurisdiction on the basis of the complementarity principles of the Rome Statute. The adoption of the Rome Statute raised hopes for the emergence of a truly global criminal justice system, embracing all member states and situations of mass atrocity. While the majority of states have now become parties to the Rome Statute, the reach of that jurisdiction remains short of the universal. Several member states remain outside its scope, and we must continue to deal with that remaining challenge, to work on securing a truly global membership of the Rome system. Article 13 of the statute provides us with an opportunity, provides the Security Council with the opportunity to refer situations not ordinarily falling within the jurisdiction of the court. As I said, the unanimity which we enjoyed, the consensus which we enjoyed at the level of the Security Council in the past has been diminishing. The Council has made referrals in the case of Sudan, but not yet in the case of Syria, I believe, and other jurisdictions where there is a crying need for the intervention of international criminal justice. Universal membership, of course, may make referrals unnecessary, and we must continue to work hard towards that and give the ICC full support in the discharge of its mandate. Until that universality is attained, however, the international community should be ready to act on this opportunity provided for us by Article 13 to ensure that all situations of mass crimes and serious violations of the law do not escape the long reach of justice. So despite many challenges, the administration of international criminal justice has turned out to be one of the most remarkable developments in the international arena. The struggle against impunity has been significantly advanced by the work of the tribunals. International criminal justice, we can say, is here to stay, despite the occasional threats of mass withdrawals. We heard earlier that is a very complicated issue, particularly from the African Union perspective. Resolutions do get adopted on mass withdrawal, but there is no implementation. There's no implementation. And while governments, many governments may be critical, at the grassroots level on the continent, there is huge, immense support for the court. Recently, as we may be aware, a few months ago, in my own country, the Gambia, the government came out with a declaration of withdrawal from the ICC and did submit a withdrawal to the ICC. It was not supported by the grassroots, by the people. And so it's not surprising, partly maybe one reason why the government lost at the election which followed shortly after. And the new government then reversed the position, and we are back in the ICC. I think there's strong, very popular sentiment and support for the court. Overcoming the existing challenges will require, among other things, harnessing effectively the lessons of international criminal justice of the past 2 decades, giving concrete reality to the principle of complementarity by ensuring that national and regional courts, through appropriate law reform and capacity building, become effective partners in the quest for justice, by securing a commitment by all states to global membership of the Rome Statute, and to equal and indiscriminate application of the law and of justice to all situations of mass crime. Ultimately, the response to the challenge of global application of the law needs to be both political and legal. The considerable gains so far made in the struggle against impunity need to be secured and expanded. The power and the influence of politics and of the law must be applied constructively to bring all nations under the rule of law. That is a task not just for us, the lawyers here, but also for all policymakers and for civil society as well. Thank you very much for your attention.
Well, you can see why I was so excited when Chief Justice Jallow accepted the invitation to be our keynote speaker. His wisdom and experience and his vision for the future is just so important and rich and perceptive. And he has graciously agreed to answer a few questions. So if there are those who would like to ask some questions, please stand up and go to the mic and do so. Great, thank you. Yeah, Jennifer.
Yeah, thank you. Thanks, Hassan, for wonderful remarks. So you mentioned a broader notion of complementarity, and one certainly could envision this, and there's a pending proposal before the working group on amendments that Article 17 be changed or the preamble to expressly recognize this. But when I look at the Malabo Protocol, I see this huge carve-out for state officials. But the ICC might well be looking at high-level state officials. So if I were an ICC judge saying, well, can they do this case at the African Court of Human and People's Rights? And I look at this huge immunity, I think it's immunity for in office. Is the ICC supposed to wait and see, let's, wait until all these people leave office, and then we can wait and see if complementarity is done? I mean, how is this relationship, how is the Malabo Protocol going to satisfy complementarity when cases may well arise within this clause?
You take one? Okay. Yeah. Thank you very much, Jennifer. That is one of the difficult clauses in the Malabo Protocol. For some of you who may not have read it, it provides immunity from prosecution, investigation and prosecution, I believe, for heads of state and what it calls senior public officials whilst they are holding office. I don't think that clause will stay like that for quite some time. I anticipate changes to it to occur in the course of time, not the least because it actually defeats the whole object of the protocol itself. If the idea of the African states was that you should not send people to the ICC, the very fact of that clause itself means complementarity will not occur. It means there is no regional system for their prosecution. If the person is not prosecuted at the national level and he cannot be prosecuted at the regional level, then the ICC will have jurisdiction, it will have competence. So it makes better sense actually to give the regional court jurisdiction to prosecute these people. So I expect that in the course of time it will be reviewed. It will change for the better, I think. Yes.
Great, thank you. Other questions?
Okay.
Charles?
Can I thank you so much, Prosecutor Jallow, for an inspiring keynote speech. And just to maybe pick up a little bit on Jennifer's concern, because I hear this a lot about the immunity clause. Are there aspects maybe that you could speak to that give us some reason to be confident that the African states would do this seriously? Because a lot of the, as you know, in terms of the civil society community, the argument is always that African states have a lot of grand ideas, but they're not willing to put their money where their mouths are. Thank you.
The action may come not only from the states, but I find it, for instance, difficult to reconcile that provision with certain provisions of the African Charter on Human Rights, which is the principal instrument to be applied by the court, which is supposed to apply the Malabo Protocol. The African Charter provides guarantees for equality before the law, for due process, for ensuring that there is effective prosecution. Now, I can foresee a situation where an issue will arise before the African court, whether by failing to, by providing immunity for these heads of states and senior public officials, the provisions of the core instrument of the court itself is not being violated in terms of equality before the law, equal access before the law, etc. I think that issue will arise. And I can easily see a court ruling, perhaps, that the provision of the Malabo Protocol granting immunity is in contravention of the African Charter itself. And then we'll see where we go from there.
Great, maybe we take one more question. David Lubin.
I would like to know what, if you were going to look into your crystal ball at the 30th anniversary of the ICC, what does the map of global criminal justice look like? I mean, not just with the ICC, but with Africa, with the states that are not states parties, with Syria. I know none of us can look into the future, but maybe you can look into the future better than the rest of us in the room.
I don't think so. I don't think so. My ball, too, is not very clear. My crystal ball is not quite clear. I mean, one can hazard a few guesses. One is that we are not likely to see the creation of any more big ad hoc tribunals. I think those are institutions of the past. There'll be more appetite, I think, for hybrids, but even more local solutions, perhaps at the regional level, for dealing with these kinds of crimes, like the African Union did in the case of Chad within the Senegal courts. They're trying to do the same for South Sudan. I think you'll have more and more of these local regional solutions than fully fledged international courts coming. And the ICC should be happy with that. I think the ultimate goal is to ensure accountability. If it's done at the national level or at the regional level or at the sub-regional level, provided it's done well and in accordance with international standards, that should be fine with all of us.
Great. Well, thank you so much for this just really, really insightful and provocative and constructive set of remarks. And we are so grateful that you made the trip all the way from the Gambia to be with us. Please join me in thanking Chief Justice Jallow.
Thank you so much.
All right, if everyone could get their seats, please grab a cookie, a coffee, we have the hardest time slot in the day, so help yourselves to some caffeine and some sugar, and we'll try to keep this a lively panel. And also end on time so that we can get you all to the reception. Well, I would be remiss if I were not to thank Jane as well as others before me for collecting such a group of interesting experts with such deep experience. I had the honor of following in her very large footsteps and is the deputy in the Office of Global Criminal Justice at the State Department, and she left very big shoes to fill. And I've recently taken on a position as the director of the Friends International Justice Initiative at the Holocaust Museum. And I've been conducting a bit of a mapping exercise of the field. Where are the gaps? Where are the opportunities? And so I get to take this opportunity to test some of my conclusions on my panelists. So I think we're going to dive a little bit deeper in this panel into some of those lessons learned and how they might apply at the domestic level, and get a sense for some of those rich lessons learned that have been alluded to. And thank you to the Chief Justice for highlighting that during our lunch discussion. One of the things that I've heard consistently in my discussions with experts in the field over the last month or so is that over the last 10 to 20 years, a large amount of the international effort has gone into developing institutions and developing the jurisprudence around international law, and that we've seen really great strides. But we're now at a political moment where we are likely to see some backsliding globally, and where we really need to be maybe in more of a defensive posture than an offensive posture. And a number of folks have identified that the real gap is at the domestic level. And so I'd like to get a sense from the panel whether they agree with that hypothesis, and if so, what those specific gaps are, and if they have other thoughts on the trends over the next 10 years. And thanks to Chief Justice Jalloh, I think he's highlighted some of those. But I'd like to give a chance for the panelists initially to start broadly at looking at trends over the next 5-10 years at the domestic level, and then we'll build and go through some of the specific examples that have been alluded to already today and unpack those. So I'd like to just open it up for now to the panels, and their bios are in your program, so I'm not going to go through each of those. Suffice it to say, this is a group of eminent scholars and experts.
Well, maybe I'll just start off just real quickly in just making a point, kind of riffing off some of the great comments throughout the day. We have a great deal of experience in international justice. Over the past 20 years, we now have the jurisprudence, the experience, as well as a good set of procedures of rules and evidence which we can hold individuals accountable at any level we choose to do so, whether it be domestic, regional, or international. One of the phenomenons that we have seeing develop is that we have atrocities happening around the world, some of them small, some of them more larger than that. But always through, the political reaction to that atrocity is slow to react. There may be condemnation, there may be concern, but at the end of the day, the atrocity happens, and the political ability or the will or the focus is 2 to 3 to 5 to 7 to 10 years behind the atrocity. And so what we have is a gap that's starting to develop, which is going to hurt our ability to do something about and account for the atrocity. Good example, obviously, is Syria, and we've, over the past 6 years now, many of us in this room have been working very hard in trying to develop a way by which we can hold what I would say at least 13 different groups accountable for what they've done to the people of Syria. And so we have this incredible ability to gather information now. I call it a tsunami of information. 99.9% of it is useless in court. There's no foundation, there's no reliability. It's an excellent historical record of what is happening. But most of it, those of us who have done this probably couldn't take that to court and get a conviction on that. Why is that? Well, it's because the political aspects of all of this have not allowed us to create an ability to gather professionally information. And so we have to really start developing an accountability center ability to immediately begin to gather credible evidence against the accountability. I'll just leave that out there. So my proposition is this, is that we need to look at more realistic ways by which we can start gathering evidence before the world can actually react to the atrocity, if I'm making any sense. And if we do that, then I think we'll go a long way down the road to have the ability 1 year, 2 years, 3 years, 5 years, or 10 years from now to actually give a package over to a future domestic, regional, or international prosecutor.
Great. Others on gaps in the field, trends over the next 5 years?
I'm happy to jump in here. So interesting that you started with gaps in response to atrocities. I think my comment sort of on the flip side of that with respect to gaps once the international community engages. And so what I mean by that is maybe the lack of sustained international support and engagement in efforts that the international community initiates, right, or supports. And I'll just give by way of example the war crime section of the State Court of Bosnia and Herzegovina, which was created with the support of the Yugoslav Tribunal and other international actors. And it is, I think, by many accounts, a successful example of intervention by the international community. But while in many ways Bosnia was a model of success, its work, I think, has been seriously undermined by the absence of sustained international engagement in the last 4 or 5 years. So the war crime section was, like I said, created with international support, significant international support. But from the beginning, it was designed to have a sort of phase out of the international support over a 5-year period. That phase out was extended, but essentially the last international judge left in December of 2012. And what I think we can observe now in hindsight is that the debate surrounding the end of the international community's support and the actual departure of the last international personnel from the court signaled a decline in international engagement to political opponents of the court that opened up space for a series of attacks on the court. So in the first 16 months after the departure of the last international judge, we saw, in fact, an onslaught of political attacks on that court. There were many ways in which this happened, but one of the ways was that political actors tried to undermine the court's work by advocating a basically overbroad interpretation of a European court decision to justify, as a way to justify the annulment of guilty verdicts in the number of subsequent and much more serious cases that eventually led to the release of accused previously convicted of war crimes and even genocide. Those kinds of events emboldened what I think were a series of legislative reform proposals that were intended to weaken anti-impunity efforts, and also resulted in a whole lot of negative media coverage about the war crime section, not to mention impacting the morale of the personnel working there. And I think the result, what we saw was some backsliding in the progress that had been made, and which I think undermined essentially the international community's original investment in the Justice Project in Bosnia. Some quick numbers, I think they've completed to date about 158 cases. They have another 346 cases in relation to about 3,300 individuals still to be tried. These are war crimes cases coming out of the Balkans conflict. So I think, the gap, I would say, is short-term thinking. Right. I think justice is a long-term project. It's really easy for gains to be rolled back, and even where the goal is to return primary responsibility to the state for justice, I think that has to be done with caution, and stakeholders need to be engaged in that process until there's a readiness for transition.
Okay. Charles?
Yeah, if I maybe I could chime in at this point because it's actually a great transition to a couple of observations I wanted to make at the starting point. And the first is actually this notion about gaps in terms of, I guess, an instance where we celebrate that there is, in fact, a willingness to do something, right? This is the almost unusual situation, right? This is the reverse of the problem. It tends to be oftentimes, right? Where, David talked about, Syria, we have this massive problem, and it came up in the panel earlier today about the accountability gap. So there's a jurisdictional limitation. The only way you can unlock that limitation is through Security Council action. And we know that's not going to happen for political reasons, not because of the question as to whether individuals are not potentially committing the crimes. This is beyond dispute. Stephen talked a lot about the evidence gathering process and what NGOs have been doing to fill that void, to create the kind of evidentiary basis so we can move forward to actually prosecuting individuals. So it's not that we don't have the evidence, is just that there isn't the political will at the highest levels, including the Security Council, which has the primary responsibility for the maintenance of international peace and security, and has exercised that responsibility in a very nice way in respect of the Sudan referral and in respect of the Libya referral. Where is the referral for the Syrian people? Yet you have a massive movement in the General Assembly, almost consensus, that the council must do something. So we don't get that. So where does that leave us? I think in terms of this conversation, we have to maybe think about the multi-level governance system that might emerge. One is the trials that would have to happen at the national level. Because even though we might have an ICC and a permanent tribunal, even when we can unlock the referral, there isn't that accountability in the mass way in Sudan at the moment. Definitely, we don't have that in respect of Libya. The kinds of accountability we hear about raise a lot of concerns, right, about fairness and basically consistency with international human rights law. So what could we have at the domestic level that might be viable? I guess the band-aids of hybrid courts or mixed courts, which is, I guess, there's a nuance there, could be one way. We have to think about going to Justice Jallo's observations. What could be an option at the regional level? This is going to be the new reality in a way, because as he suggested, and I think this is a point that goes way back to Kasese, who says, well, these tribunals are passé now, like a full ad hoc international tribunal, too expensive. They're just not going to do it. He would want to have it, but he knows the political will doesn't exist. So in a sense, it raises the question whether we ought to be more open to the idea of regional mechanisms. What kinds of regional mechanisms? That would be the question. And Jennifer raised the issues of justice back to the Malabo Protocol. So what do you then do when you have created a regional jurisdiction that is very expansive, and then on top of that, you go right for where we are most concerned, right? You carve out the exception. It defeats the purpose of the AU in terms of what they're trying to accomplish. And in my view, it in fact shows the political nature of some of these mechanisms. And the end goal ought to be that we could use what states are trying to do against them, because ultimately the first iterations of the immunity clause were consistent in the African instrument, in the Malabo Protocol, 2010 draft and all of that. They had exactly on all fours with Article 27 of the Rome Statute. So the position on immunity by African states was consistent with the position we've seen in the ICC statute, in the Rwanda Tribunal statute, in the Yugoslav Tribunal statute, in the Sierra Leone Tribunal statute. There was a particular moment there that opened and they jumped on it. Maybe that moment has passed, so I'm a little bit optimistic about that. Final point about international mechanisms. So we will then have domestic trials, regional trials, and at the final level, the International Criminal Court. I think the expectations problem, Jane, you mentioned that earlier, I think it's a huge problem for the court, because even in the best of times, they don't have the money to do all the work that we want the ICC to do. We heard a lot about budgets this morning. They are told, do more with less. Again, because the political will is not there. Let's put that in context as advocates for this cause. The amount of money we're talking about is peanuts. Peanuts compared to what we do with defense spending, for example. I'm not going to name names now, okay? We all know who we're talking about here. So my point is that it's not the massive billion-dollar project. It's a small amount of money. John Washburn was talking about, 147 million euros? You kidding me? It's a lot of money for me because I don't have it, but it's not a lot of money for governments, right? So I'll stop there. But I think there are gaps. There are gaps of law.
in terms of the legal regime we have. There are gaps of political commitment, putting our money where our mouths are in terms of accountability, and recognizing that the long term of all of this is we gain, if we actually step forward and act in advance of these atrocities, we gain a lot more than coming in at the end, as David was saying, and they're kind of trying to throw a Band-Aid on it at the end. I stop there. Thank you.
Thanks, Anna. I'll jump in with a few thoughts. And first, thank you. It's a real pleasure and honor to be here. And especially nice to have a brief reprieve from the very glamorous fluorescent conference rooms and linoleum hallways of power at the State Department. And as I'm in an academic, as I'm in an academic setting, actually permit me a bit of an academic response to your question. There are, of course, plenty of technical gaps in the field and political gaps. But I'd like to note a sort of discursive gap. I think we live in a global moment where there are, our attention is being demanded to address a range of very urgent national security and global security threats, including terrorism, transnational organized crime, refugee and migration crises of historic proportions, man-made famines across Africa and elsewhere in the world. And for the practitioners, experts, advocates, and diplomats who focus on atrocity crimes, the imperative of addressing these crises threatens to overwhelm the salience sometimes of why we should. So I would proffer a suggestion that we need to be better at shaping and honing arguments that that position the need to ensure accountability for mass atrocities as part and parcel of responding to these overlapping urgent global and national security threats. And understanding that yesterday's war criminal in Central America is quite often today's narco trafficker, and that the threats posed to the international system, but also the sovereignty of national states, comes from at base a root cause of impunity for these crimes and other crimes. So it's a way of, I think, perhaps reorienting the way we position our arguments and the way we present the urgency of countering these not only as a moral imperative, but as a national security strategy.
Thanks, Stephen.
Well, so I'll do the opposite because I'm a practitioner. So, and I don't know how to give the academic answer, and my answer is not very much in line with what we've heard, although I fully agree. I think because I work in a team that works mostly with national courts, and we do believe that the heavy lifting is to be made at the national level, and the principle of complementarity existed before the ICC. One thing that we always find is that there's a big gap on technical capacity. If we want to work with national investigators, it's not enough for us to create commissions of inquiry, to equip our NGOs to do extensive amounts of documentation. As David noted, we know exactly what's happening. We know what the crimes are. If you really spend 48 hours doing a really good Google documentation, you can do the chain of command of ISIS on your own. You don't need to be, you don't need to be a rocket science investigator. You just need to put your things together. And then you need to go to people who actually have the legitimacy and who are investigators and prosecutors and judges in national systems and can do this. And they exist and they are there, and we just need to work with them. And going back to David Mendel, Anthony, observation on, yes, we are living in an era of transnational crime, of migration, but all of this is a result of atrocity crimes. And in the context of all of this massive, terrible things, there are atrocity crimes being committed. So if you go to Mali and you work with the anti-terrorist unit that was created by the government, don't train them in terrorism only. Train them on looking at the links that these groups have doing trafficking of women, sexual slavery. How do they connect to Al-Qaeda? How are they being connected with the groups operating in Nigeria and Niger? How do they connect with the others? And you can train people doing anti-terrorist actions on atrocity crimes because they are there. So I think this, for me, it's the major gap. It's a gap of technical capacity and working more with the national authorities. And as Susanna said, making it sustainable, because it's not enough to have, you know, a humanitarian, like a nice DRL grant of 1 year, because it doesn't solve the problem, because this is not a 1 year commitment. This is a 2 years, 3 years, 5 years, and you need to develop, and we work in countries where the judicial systems, we know that they don't exist, but the solution is not, because the ICC is not responding, to come up with another regional court that then we will take 3 years to create, 5 years to staff, and then 7 years to close down, and that will do nothing for the national system. So, I mean, we've learned the lesson. So, yeah, so I think this is where the gap is I think the UN maybe should create another committee on lessons learned.
So that takes us to our next set of questions, going from broad to more specific on lessons learned, what those are, and then actually how they can apply. So I'm going to challenge you a little bit, my panelists, to actually look at how we might apply those, since we have those lessons. So that's specifically, I think, pertinent right now as the ICTY and ICT are closing, and we've heard about some of the retrospectives that have been done. But those are very different tribunals than what we're now seeing, as the Chief Justice said, more and more local, more and more mixed courts, and even a broader array of transitional justice mechanisms beyond courts. So how do you take the lessons that we've learned at the very international level with, although I take your point on DoD budgets, the budgets for these courts are still, you know, immensely far greater than we're going to see, I think, for the mixed courts. So how do we take those lessons and apply them? And maybe one specific example, David, I think when we had an earlier conversation, you mentioned the outreach efforts lauded by the ICTY and lauded about the SCSL, but yet there's a lack of serious critique about those. So what worked well, what didn't? How do we actually then apply those lessons to the very local mechanisms that we're likely to see over the next 5-10 years? So maybe, David, I'll start with you, and then Charles and Susanna, and then I'll open it up to the group to respond.
I think what you're alluding to is that we have to take what we've learned and be realistic and shape and mold our reaction to atrocity in a way that is, as I would look at it, as legally, culturally, politically, diplomatically acceptable to the country, the people, the victims, the region, as well as the international community. We have to be very careful in just reaching for a court. I think we're already alluding to that the real future of modern international criminal law, even though over the past 20 years it's been focused on courts and tribunals, it truly is, and I think it's already been driven home very well already, is in the domestic systems. And yet we have not really focused, as we've also talked about, very well on that ability to train and to create, allow countries who are willing but just are unable because they don't have the capacity to start teaching and training them. Because again, I think that the trend is certainly away from a broader international reaction to an atrocity and trying to deal with it at a more local level, and that's already been said. So, you know, and was asked to go to West Africa and help create a brand new idea called a hybrid international war crimes tribunal. I took ideas and I said, we're going to do this, we're going to do that, notice pleading and shortened indictments and representational charging and looking at gender crimes in a new light, such as making it a cornerstone of our indictments, looking at new ways which we could take the concept of a crime against humanity and the term other inhumane acts and use it as a force of a reactive force to create new law, and we did that with forced marriage in times of armed conflict. I'm not touting the special court for Sierra Leone. I'm touting the point is that we have to be very open-minded and look at new ways by which we can seek justice for victims. Because at the end of the day, and I remember telling my office almost every day, the only reason we're here is to seek justice for the victims. These courts, these mechanisms, these ideas are all based on seeking justice for the victims of atrocity. Now, you mentioned some of the challenges of getting people to buy into the rule of law. And one of the basic concepts that I always took out when I went on the outreach program was that I always tell them that the rule of law is more powerful than the rule of the gun. And many of you already heard me say that probably all too many times. The point is that you have to get down to the level of the victims, the people that live in the area, and make them feel that this is their effort and that you're here to help them do that. And so that's where I think it's also something for us to consider as we look at accountability. We have to look at it at very many levels. Legally, we've talked about that. Politically and diplomatically, I think we're beginning to realize that politics, the bright red thread of all of this, is important, and that you have to take the political and diplomatic impact of whichever you're doing, locally, regionally, internationally, and try to figure out how does that impact on the area. And I think, frankly, the Darfur decision of just jumping in without asking any regional actors as to how do you think this would react, it was a disaster for the International Criminal Court, and it's unfortunate it was one of the first things that it ever did, and it's still, this is a cloud hanging over it. So that I think we're getting better at now when we're looking at an atrocity, whenever we react to it, we're looking at it at many, many levels. So the diplomatic and political aspect of an accountability for an atrocity, I think, is as crucial now as it always has been, and it allows us to be imaginative. One of the things I think we need to also pay close attention to is the cultural aspect of justice. Is the justice we seek the justice they want? We're very arrogant in this. We have all of the answers. We're the international community, and we come out of nowhere and we provide them, we're going to take care of the situation. But no one ever asked through an outreach program or what have you, what does justice mean to you? And I think that that's very, very critical. And I call this the spaceship phenomenon because this, literally, I remember in our white UN helicopters, we'd go out to an outreach event, and most of the people watching that helicopter land in that landing zone, they thought it was a dragon. Literally a dragon, and out the back of this dragon, I would step. Now, that's not a good image to think about. But again, you have to realize that these people are terrified of you in one form or another. They don't know who you are, and so you have to be humble enough to realize that you don't have the ability to seek justice for everyone, but then you ask them, what is a just result for you? And we're going to be surprised to find out that there's all kinds of justice in the world, and it's not Western justice, it's justice in the eyes of the victims. If the victims think justice has been done, then we're moving in the correct directions. Because if we don't think that through, we're going to be wasting a lot of time and effort when the people look at each other going, this wasn't justice, I'm very dissatisfied, what have you. So again, putting this in the place of, well, what's going to be happening, where we're going and stuff, I think that we all have to step back and realize that we do have to think at it at a much lower level now. We were in the heady days of the ICTY, ICTR, Sierra Leone, so we were off just ICC. We were at 35,000 feet. We're realizing that we're we're flying over and missing a great deal of the topography of justice. And so we need to get into that little Land Rover, crank that baby up, and keep it at the dusty road level. And I think we'll find that we'll be doing a much better job at justice in the long run.
Thank you.
So on that note, I have been on those helicopters that David talked about. And I make reference to that not to show that I was also privileged enough, like the prosecutor, to ride the fancy UN helicopter, but to underscore.
It wasn't that fancy. It was an old Russian helicopter.
Well, but
Yeah,
David.
in fact, I was, yeah, durable, yes. But they had a tendency to stop working in midair.
Yeah, with the
Please, I didn't.
with the no, totally fine with the almost half drunk helicopter pilot, but I won't get into that. Yeah, no. So just to make the point that I think to underscore what David was saying, that we got to, I think at this step at this stage of the conversation, we got to be more humble, more modest. There is no one-size-fits-all approach to accountability. And accountability, and lawyers can be a little bit arrogant, to say the least, right? Accountability must be understood in a wider sense. Justice must be understood in a wider sense. And so I want to start off by underscoring that point. And the reason why I say that will become obvious in a few moments in terms of the 3 points that I want to make. One is if you step back, so I'm going backward now looking at the special court and some of the lessons from that period. We know politically it's just not going to be possible to come up with all the resources and the support. I guess the Security Council is no longer as naive as it was once in 1993 and 1994 when it thought that, you could do international justice in this sort of at 35,000 feet coming in with the helicopters and even more fancy things. We don't give up on that idea. So there is a place for that. But that's criminal justice. That's a very narrow type of justice. And Sierra Leone gives a perfect case study of an instance where we actually try to broaden the viewpoint, not because of political will, as in there was a design that we will have criminal accountability alongside a truth commission, which is what ended up happening. It's just because of the way the conflict played out. So the initial position of the government, for the students in the room who may not be aware of this, let me just pause there, it was we don't want criminal prosecutions. So we'll have a TRC process, a Truth and Reconciliation Commission. We'll give a broad amnesty to the combating parties and everybody will move on. It was a dissatisfactory result for civil society, for a lot of the population that had suffered trauma that had not been experienced in Sierra Leone. So there's a lot of pushback. But the government went forward with it anyway. Sure enough, because the voices were there who said this is not a viable strategy, it came back to where the concerns were that, no, this is not going to solve it. It's not a viable strategy. You got to prosecute at least some people. So we know what happened. They basically unraveled the peace agreement that had given them the amnesty. The government at that point hit the berserk button, went to New York and said, help us set up a court. We want to put these guys in jail. That was basically why Sierra Leone ended up having a special court for Sierra Leone and a Truth and Reconciliation Commission. Now, if you look at the outcomes of those two processes, clearly the international community supported heavily, and I say this in quotations because it's really like heavily, as in like a few $100 million over 12, 13 years, fairly good results, but modest results in terms of criminal prosecutions. Yes, people bearing greatest responsibility at the top, in fair trials and all of that, but it's a small number of people, less than 15 people. The Truth Commission, on the other hand, that did not generate a lot of support. I mean, it got the support of OCHA, the UN, number of other actors, but struggled, like the Special Court, for funding throughout its life, ended up having these hearings and coming up with a fantastic Truth Commission report, multi-volume, all kinds of recommendations, a lot of which are deep recommendations, so going back to sustained commitment, very little of which has been implemented. So one of the lessons of Sierra Leone is that we got to be able to think about accountability broadly. So it's criminal, but it's also the possibility of truth commissions. And on top of that, what are we willing to put in the kitty for the long term? Because ultimately, it's not just prosecuting a few people and saying, yeah, we did our job, now we're off. Because where is Sierra Leone today? Where would it be 10, 15 years from now? I don't know. My guess is as good as yours. But the examples we see in conflict after conflict is that the picture is very complicated, and saying that prosecuting people is enough is just the beginning of our effort. It ought to be the beginning of the effort. Now, in a world of limited resources, we have to choose our battles. But my point is that a one-size-fits-all tells us that maybe we can be more modest in pushing accountability in a different sense, because then one of the things that could have changed in Sierra Leone is that victims might get more support. That's reparative justice. That's not retributive justice. It's getting more support for all the amputees that are on the streets of Freetown up to today, people who suffered massively. And one of the regrets that I have is that the Sierra Leone government never had the resources, or actually even the political will, to be honest, to put money to help those who had suffered in that kind of way in the context of the conflict. So the takeaway for me is accountability. It must be understood broadly. It's modest, it's criminal, it's also plus, it's retributive. It has to come in other ways. Otherwise, the victims will not buy it. That's not the justice that they were seeking in Sierra Leone. That would be the answer that David would hear when he goes around the country. Second point, this is important. Now I'm going to go to look forward. We got to be creative, and this is your point. We got to hit states where they are interested in most. And let's be honest, transnational crimes attract their attention. They're willing to put resources fighting drug wars and what have you. But there are clear links between the people who commit these crimes and international crimes. And I was fascinated in The Hague at a small side event that we did with the deputy prosecutor of the ICC present, him talking about the evidence that they had uncovered as ICC prosecutors that they were turning over to Libyan authorities. This is about mercenarism, gun running, all kinds of stuff that would, in the traditional international criminal law, attitudes like, oh, that belongs over there. Well, you know what? It belongs here too. And we got to maybe build on that and be strategic in the way we push cooperation regimes, because there's stronger cooperation in transnational criminal law, a system of mutual legal assistance that's very deep, that's very embedded. So in a sense, we can bring in atrocity crimes underneath the radar and try to influence the kind of cooperation. Because, of course, the ICC suffers a lot from lack of cooperation. What if we had a cooperation treaty? There's a movement for that. I don't know whether it's going to happen, but maybe we'll get more play if we push it in the transnational crime point. Final point, and this is the point about the role of African states in all of this. The African states have done a lot under very difficult circumstances. There are, of course, lots of criticisms that can be leveled, but let's not forget there's pushback against international institutions. So we need to be able to work with the governments that are willing to work with the system, to give them the encouragement. And the Habre trial is a perfect example of that. They didn't rush to the table to prosecute Habre, but because of civil society push, because of the support of the United States, because of the support of European Union partners, we got some justice, limited though it may be. We got some justice in that situation. And my point is, give credit where credit is due, because then you help build the system. This is a long-term project. It's not a quick effort. We started before Nuremberg, and we're going to be doing it for a long time. And we got to be modest enough to accept that and do the best we can in the moment that we're in. Thank you.
So I'm glad that the previous panelists started broad, both David and Charles, and I think those were excellent reflections on lessons learned. I'm going to offer, again, I'm going to go more specific, more narrow, more specific. I want to focus my remarks on lessons learned from the ad hoc tribunals, which you mentioned early on, Anna, and in particular from a project that I've been involved with at the ICTY, at the Yugoslav Tribunal, with the Office of the Prosecutor. And the project was designed to capture and memorialize some of the lessons learned regarding investigation and prosecution of conflict-related sexual violence. The project, I think, was interesting in part because it focused not only on what they did well, so on the cases that you all probably know about where rape and other forms of sexual violence were successfully prosecuted, but it also, interestingly, took account of missed opportunities or missteps and what the OTP could have done better over time. And the result was a book that was released last summer. The title of the book is Prosecuting Conflict-Related Sexual Violence at the ICTY. And I think what's interesting about it is, again, in a very narrow part of this whole discussion, it offered a thoughtful and I think a very candid assessment of what the OTP's efforts at the ICTY, the prosecutors' efforts at the ICTY, a candid assessment of what worked well and what didn't. And I think I sort of think if you look at the lessons in this book, among the most important lesson was the recognition that sexual violence, even at the ICTY, perhaps more than any other category of crime, was subject to misconceptions. And misconceptions that impeded clear analysis of sexual violence acts and the connection between those acts and other forms of violence, making it extremely difficult to investigate and prosecute those acts. And so at the heart of the problem was maybe this failure at times to fully recognize rape and other similar crimes as violent acts. What happened with that in a context where investigators are overwhelmed often by an overwhelming amount of criminality is that where there's a tendency to see sexual violence as not fully a crime of violence, that kind of crime was given low priority, right? Especially, again, in a context where there's high criminality and low resources to work with. And when sexual violence was not fully recognized as similar to other violent acts, there was also a tendency to see those kinds of crimes as maybe personally motivated, opportunistic crimes, which had the sort of subsequent consequence of sort of justifying lack of investigation. If they were opportunistic crimes, then we would really be going after the direct perpetrator, the direct physical perpetrator, and not the senior officials or those most responsible that are the subject of at least the international and some of the hybrid tribunals that we know about, right? So I think that the interesting thing was not just the identification of the problem, but also I think OTP's development of strategies to overcome them. And these are strategies that I think could also be applicable at the national or hybrid level. One was, for instance, arguing that certain crimes requiring proof of a violent act include acts of sexual violence. So when we prosecute rape as torture, you're indicating, you're proving that there's an infliction of serious pain and suffering, bodily, mental pain or something. Same thing with genocide. You're showing that there's serious bodily, mental harm that's inflicted with an intent to destroy the group. I think those strategies happened early on, but could also be followed in other systems. Second, I think the OTP was able to use what's known as joint criminal enterprise liability, which I know some have critiqued. But I think it was an important mode of liability to hold responsible perpetrators who act together to bring about a criminal result, regardless of the role each perpetrator had played in the physical commission of the crime. And so I think that allowed prosecutors to hold higher level perpetrators, not just physical perpetrators, responsible for sexual violence when it formed part of a group's criminal purpose, even when, again, the perpetrator was physically remote from the scene of the crime. I think more generally, the ICTY's review of their work in this area yielded a number of other, maybe more operational lessons, including, and I think this was talked about in the previous panel, the recognition that some of these misconceptions are really powerful, and the investigators and prosecutors are vulnerable to relapse. And so, meaning ongoing training about both the misconceptions and how to overcome them is critical, as is the development of written policies on these issues, and maybe even the designation of senior level folks in different parts of the court, in the prosecution, maybe even the registry and the other section of the court that are gender focal points in those units. And one last thing I will say that the OTP emphasizes is that, in terms of lessons learned, is the need to think creatively, again, about how to prosecute these cases, how to prove these kinds of cases. There was often a feeling in the beginning that victims would not want to step forward for reasons of shame and stigma. And I think I'll read you a quote from the book. The ICT experience has shown that, quote, stigma is not an insurmountable barrier, provided the OTP creates conditions during the trial and pretrial process that ensures their safety and well-being. On the other hand, witness testimony is not always necessary. You can prove these cases with other kinds of evidence. So there's some real practical, I think, lessons in that volume that could be used at the national level.
Great. One of the things that I've been struck by, and Charles and David, you both mentioned it, around needing to have a victim-centered approach and what that looks like. one of the things that I've been struck by as I've talked with folks during my mapping exercise is that the very group that has the greatest interest in pursuing justice is the very group that is least resourced, and that is victim groups. And I think the Habre trial is an interesting case study around that. And I'm wondering, maybe Charles and David, if you can say a few words about that. And then Susanna and Sophia, having worked in a number of situations with victim groups, if you can kind of say a little bit around lessons learned around making the rhetoric around victim-centered processes actually into a reality.
Sure, I'll say a few words. I think the Habre trial is actually the perfect case study because the central protagonists of that story for 25 years were a group of extremely tenacious and courageous victims. If anyone in this room has met them, they absolutely blow you away. Jacqueline Modena and Suleiman Gang and others who, against all odds, fought for decades. And I think their experience leaves us with a number of lessons to learn, which is that justice takes time, often. Also that when it seems that the tectonic plates of geopolitics might never shift, it's usually the victims who hold out hope they will, and that one day they might. I also think that taking a step back a little bit theoretically is that if you are a policymaker wondering what a post-conflict or post-authoritarian society can best do to address a legacy of mass atrocities and to transition into a stable, secure, and democratic space, some of your best guides to answer that question will be victims, because the needs they identify regarding accountability conceived broadly, not just in a retributive accountability, but the needs that victims identify are the very types of institutional reforms that societies need to undertake. Victims ask for quite concrete things often. They ask for their medical care to be provided, or for limbs and other parts to be restored. They ask for security forces that protect them rather than abuse them. They ask for prisons that hold those accused of crimes rather than those accused of exercising political freedoms. If you take the articulation of victims seriously, what it does is it helps transform victims into active citizens and agents, and it helps focus, I think, the international community on broader needs of societies. In the Habre case, the long and winding saga through half a dozen national and international jurisdictions that resulted in conviction of Habre at the hybrid court achieved some pretty notable victories on the way. So it's sometimes also not just the conclusion. In Chad, there were domestic prosecutions of several senior-ranking former members of the Chadian security forces under Habre. And while the victims in Chad were absolutely astonished that this happened, the result of those convictions was not simply confined to criminal accountability. I think another lesson is that in the quest for criminal accountability, sometimes you can find ways to broaden the aperture. The Chadian court ordered the government to take a range of reparative measures in Chad, which included memorialization efforts to transform the infamous piscine, which was the swimming pool that had been used as a torture center by Habre and his DDS, to transform that into a site of learning and memory and remembrance for the victims. It asked the government to take responsibility. The court ordered the government to take some responsibility and issue statements of apologies, which is a form of symbolic reparations. So I think if you follow the wants and needs of victims, you'll end up with a more broader look at what societies need actually to address mass atrocities.
So just to jump in, because Anna invited me to, I think David has really done a masterful job of summarizing and bringing in this perspective of the Habre trial. If you step back from that ever so slightly to kind of expand your point a little bit, I found it fascinating. I have here the report of the Secretary General on transitional justice in post-conflict situations, and this is a 2004 report. So 2004, many, many years ago now. And the Secretary General did this study, and it was fascinating to me what they said about victims. So of course they mapped on and talked about international criminal tribunals and the lessons we learned from those, the hybrid courts, they talked about Sierra Leone and what have you. And then there's a paragraph 54 on page 18 that talks about delivering reparations. And one of the things that struck me about that will be apparent in a moment. So the UN says that they were involved in the question of reparations for victims of crimes in the Gulf War, and that the UN Compensation Commission, the United Nations Compensation Commission, had processed more than 2.5 million claims. These are claims by victims of the Iraqi invasion into Kuwait, and get the number that they had spent. They had paid out more than $18 billion to victims of Iraq's unlawful invasion and occupation of Kuwait. Paragraph 54 of the UN report on transitional justice from 2004. $24 billion out of one instance of, obviously significant threat to international peace and security. There was global action, there's political will, and we know what happened in terms of the steps that we're taking. But this is the aftermath. Okay. Now you're talking about long-running conflicts that last for decades, and in the case of Habre, a period in power that was particularly traumatic. So the victims were central to even getting to justice, and on top of that, they demand more. So when you look at the statute of the Habre trial chamber, they provided something very similar because of the continental European system of partie civile, where you can kind of have civil actors that are part of the process, but also can seek some kind of status to get compensation. And the ICC is dealing with this now. We heard about decisions issued at 3 orders. We don't have the funding for them, but they are attempting to come up with at least some symbolic reparations at a community level, but also even individual reparations for those who had victims standing before the court. Where does that leave me? Well, it leaves me to the observation that this opening up of the aperture, as you put it, David, is important because, again, if you go to the areas where we see tribunals, one of the criticisms is that they didn't do enough for victims. And the UN acknowledged in another part of this report that one of the recommendations that they had gotten from the ICTY and ICTR is that there should be a special compensation fund for victims so that alongside criminal accountability, there will be this kind of reparations for individuals and even communities. Again, this is a massive global effort. This requires sustained commitment. Obviously, the Security Council that is always chasing global conflicts has a fleeting attention span because it has too many issues to deal with. But a lot of it comes down to the political will. So one of the takeaways from the Habre Chamber and the ICC is that even though we may design some reparations for victims into the mechanisms, the extra step of the political will to fund that is missing. Why was it possible in the context of Iraq? Well, the country had to pay the $18 billion, and that was the difference, right? In a lot of these other situations, you don't have those deep pockets. So again, our creativity cannot be, we have to be even more creative as we go along in terms of responding properly so that it's truth commissions, it's criminal courts, it's vetting processes, excluding people who have been destructive from running for political office, using domestic and international means to ensure that that would happen.
Yeah, why don't you go first?
Yeah. Okay, so I was asked to talk a little bit about the victim-centered approach and how we, in the context of sexual violence, have seen the practice evolved. And the truth is that I think that we are all very aware that there has been a progress made, that we are now getting off the spaceship and coming down and trying really to look at the victims and start on the victims. I think, of course, for sexual violence, that's especially challenging because of the issue of stigma. It's not an obstacle that cannot be taken. I think it can. And I think I would like to talk about 4 points. So the first one is going back to the example of DRC, Congo, where we've seen that local justice has actually most of the cases of conflict-related sexual violence have been committed in Congo, have been investigated, prosecuted, and tried in Congo. They have not been tried by the ICC. They have not been tried by other courts. They have been tried by Congolese prosecutors in Congo. And in Congo, there's a huge stigma on sexual violence. And we started to work in Congo around 2008, and we are now 2017, so it has been 9 years. And if you knew Congo in 2008 and if you know Congo now, you see a huge difference. You see a really, really big difference. In the beginning, it was very difficult to talk about sexual violence. There was a huge denial that sexual violence existed. Sexual violence was brought to Congo by FDLR. It wasn't something that happened in FDLR, the Rwandan forces. It didn't happen in the Congo. Very few people were willing and able to file complaints. So the approach that was taken, and I think that there was a very close cooperation with the local authorities. And first of all, there was a lot of awareness raising that was done with the victims about the crime, but also about how to file a complaint, what kind of assistance they could be provided. And the first assistance to be provided is not justice, because the priority of a woman or of someone who suffered and who lives in those conditions is not justice, it's else. So we started to build a referral pathway that would start by providing the people with medical services. And the model of investigation and prosecution that was created was a referral pathway that started by providing medical assistance and then putting the doctors or nurses in touch with the investigators and the police in touch with the prosecutors, and the prosecutors in touch with the judges. Nobody is naive. Everybody knows that it's a very corrupt system. So this sounds great in practice, but it really doesn't work. And 9 years after, it still doesn't work. But it works much better than it did before. And now we have special police units. We have 9 special police units that focus on dealing with women and children, where women actually come forward and they actually file their complaints in the police. A number of international organizations, IRC, ICRC, WHO, UNICEF, everyone you can imagine provides medical assistance. So the Congolese state kind of outsourced public services and medical assistance. So the women can actually go to the hospital and they are given the choice of pursuing the case or not. So this is something where we slowly empowered victims, and we created the conditions for victims to come forward. I think David touched a very, very important thing, which was our objective is not we are not in countries, we are not in Norway or Sweden. Our purpose with justice is not only to have a punitive measure or to compensate the victim. It's transform victims to agents, to citizens, to victims, justice users, citizens. This is what we want at the end of the process. And if we don't do this, we fail. So one of the things that we continue to fail in Congo, so we fail in many things in Congo, but one thing that we really, really fail is we have given access to the women to go to the hospital, to the police, to the prosecutor, and we usually actually have trials. So some people go to prisons and some escape, but one thing that we systematically fail is to pay reparations to the victims. And we go back exactly to the reparation issue, which is we finally get a woman to go to court to deal with the police, and she has expectations at the end, because this is not, our victims are not freedom fighters, political people, academics. In Congo, our people and our victims live with less than $1 a day. What they want is, they want us to pay the transport to go to the court, so they can pay the tuition of the school of their kids and they can go back home. This is what they want. They need reparations. Not we, but, their lives were destroyed, so they need reparations. So if we oblige them to actually, confront all their devils, come to court, do everything, and then at the end we say, here's the paper, and the paper says that the state owes you $500, and the state fails, these are not going to be justice users. These are going to be people that will not go to the police station and to a court again. So transitional justice fails. So rule of law, so building the rule of law and trust in the institutions fails if we fail to do this. So this is a big long-term project. So I think this is one of the things that we can claim to have a victim-centered approach, but then if we fail this, I think another thing that I don't want one thing that I don't want to forget is one thing that in Congo I think it was very important was that looking at what happened, so I mentioned we did awareness raising, there was a lot of legal education, there was legal clinics, all of this was provided for free thanks to the cooperation of donors and agencies who were there. And it worked because everyone took a little bit of the cake and everyone put money into this. Now, there's a big issue. We also did a lot on witness protection. That is another issue that is crucial on this. It's witness protection is not developed in most of the countries where we work. And it was extremely important to put this on place. And it was MONUSCO, the UN peacekeeping mission, who took the lead on this. So everybody took a little bit of the piece. So now I mentioned that we kind of outsource this great public service that is called justice. Now, if we don't outsource this and if we all pull the plug, is this sustainable? Is this going to stay in place? And this is a question that we need to ask because Congo is really, how can I say, it's not in peace. So, if we come out today, what does it happen? Is the rule of law strong enough to survive on its own? So I have 4 things. I think I touched them all. So just my last thing is, and it goes back to what David said, which is listen to the victims. I think one thing that we learned is that we need to listen to the victims. We need to hear what they have to say and what their expectations are. And I think that this is a lesson learned that is not only that touches the victim-centered approach, because this should be the voice of the victims being heard. And I think what we've seen in the last years is that we now do surveys to know what the victims want. And I think policymakers should actually look at them when they
Some of us do.
Yes, not enough. But I think it's very important to do this. And I think that even the UN, which is not known by its modernity and approach to news, openness to new things, has been conducting in DRC and now in Central African Republic surveys conducted with the assistance of Harvard Humanitarian Initiative to know what do victims want, what are the perceptions of security and justice, and how this evolves throughout the years. So now that we always claim that, there's no way to show how the presence of rule of law institutions or courts really affects the sense of security of the population. So now if we actually commit to this, and if donors commit to this in the long term and continue to pay for the surveys, we will be able to track the progress and understand what is the real impact on how people perceive what is being implemented, and if this changes or not the sense of security. So
I don't know if you, running short on time, but I thought I would offer a few comments that sort of piggyback on this from the perspective of the ICC's victim participation scheme. I think a lot of the themes we've touched on come up in sort of a critical analysis of the victim participation scheme at the ICC. one of the sort of pivots, you started with reparations, right? One of the interesting things about the victim participation scheme is it was designed in part with the idea that it would be part of the restorative justice process, right? It would be not only aimed at punishing, the idea that the ICC should not only punish wrongdoers, but also serve the interests of victims, right? And so there was, another theme has been expectations, right? Heightened expectations, both in this panel and the earlier panel. I think there was this heightened sense of expectation of what a victim participation scheme would be able to deliver at the ICC. And I think if we step back, the record is sort of mixed, right? I think that there has been a great interest in accessing the victim participation scheme at the ICC. You see that just by virtue of numbers. I think I don't have most current figures, but a few years back, something upwards of 16,000 victim applicants applied to participate in proceedings before the ICC, and maybe 9,000 or so were accepted, were admitted as victim participants. There have been anecdotal and other studies talking about the ways in which victims have found their participation meaningful in some ways, right? There's one particular, it's interesting because it's not quite what you imagine in terms of victim participation, but one example is in the Kenya case when the registrar's office was interviewing and kind of seeking the views of victims on the ground in Kenya before opening the investigation. They collected views of victims, put it in a report that went from the registry to the court with views of victims that really would not ever have seen the light of day in a court proceeding, but where the registrar said the victims found this important, they wanted to present these before the court. And so that was a way in which victim participation, though maybe odd, found, I think, was meaningful to the victims in that case. On the other hand, that's not the full picture, right? In the ICC, victim participation has been plagued by challenges. One has been long delays in the assessment of victim application, not just whether they qualify as a victim, but then whether or not their personal interests are affected in a way to trigger their participation via the Rome Statutes, Article 68.3, which requires them to show personal interests. But they've also been affected, I think, in other ways, which is one of the fundamental ways, I think, is representation. So to the extent that victims or the victim participation idea was sold as this idea in which victims could come and participate directly in proceedings during the trial, talk to the court, have a sort of moment, an unfettered way to talk about their story, that really hasn't been the case. That has been very unusual, where victims have been able to present their views and concerns to the court, directly. What has happened, particularly in the cases where there have been thousands of victims engaged in a case, is that there have been common legal representatives appointed to victims, to large groups of victims. So Lubanga, maybe there was 100 or so victims, not so many, but Bemba, where you go to thousands, 4,000 or 5,000 victims, you still only had one or two common legal representatives representing a large group of victims. And so that obviously presented an obstacle to unfettered kind of access, restorative justice access to the court, right? Because I think the idea was that advocates thought in some way, it was not quite clear what the idea was, but maybe the idea was that, somehow providing participation would promote victims' healing and rehabilitation to the extent that victims' voices were heard, were respected, were understood in the process. Somehow that was going to be restorative. It would bring proceedings closer to victims, certainly than maybe they had been in the ICTY and ICTR, where there was little outreach in the beginning, unlike the Special Court for Sierra Leone. And so there was a kind of disconnect between the victims and the work of the court. There were all these expectations, and I think in the end, victim participation has been meaningful. I don't want to be mistaken, but I think it's been different than what victims had hoped it would be, and it's been mediated through common legal representatives, the job of which is to figure out what thousands of victims might want in these proceedings. So I think what I would say is, and I've written about this elsewhere, I think we should spend a lot more time and energy exploring other possibilities, reparations, other possibilities that might be equally, if not better suited to fulfilling restorative justice goals, to really paying more attention, about the points that Sophia made about victim reparations in individual cases, and maybe other better outreach, better communication with victims. I think there's a whole wealth of ways in which we can improve victim-centered approaches to criminal tribunal efforts, and not only expect victim participation or even victim reparations at the ICC to do the job.
Great, thanks. It's hard to talk about victims without talking about Iraq and Syria and South Sudan. So I think maybe we'll close out this last round of questions and then open it up to the audience about some of the developments we're seeing on Syria. David, I might ask you to talk a little bit about the triple IM and what that may or may not, how that may bear fruit, and how victims might seek engagement with that mechanism. And then also looking at Iraq, and I know Sophia's just returned from an assessment with the SRSG for sexual violence and conflict in Iraq. And I'd like to hear maybe a little bit about what you saw on the ground in terms of what victims want and how they might engage with either domestic processes, probably in the short term, but potentially some of the international initiatives that have not yet gotten off the ground. And then if folks have final thoughts on South Sudan, we've heard a little bit about the hybrid court, Charles and others, to speak about how victims may think about the Habre model there, given where the government is on that situation. So with that, I'll turn it over, David.
Thank you. Many of us in this room have been working on Syria since March of 2011, and I know I certainly have, and with the Syrian Accountability Project, where we're building a trial package for a domestic, regional, or international prosecutor, using the very techniques that I used when I was in Sierra Leone. Over the years, we began to realize that establishing a court or a tribunal, whether it be domestic, local, or regional or international, it just wasn't going to happen in the foreseeable future. And yet we had all of this, as I alluded to in my opening remarks, this petabytes of information, which I understand is 1,000,000 terabytes, which is 1,000,000 megabytes. I'm really taxing my technological ability. But the point is that we're looking for needles in haystacks. There's too much information, and like I said earlier, most of it is not useful in court. Well, in the end of the summer, just before our convocation in Nuremberg, I've been working with a group of, offline a bit, with a group of ambassadors to consider various ways by which we could seek justice for the people of Syria. And I met with a couple of them at the end of August, and I said, I'm really concerned now that we have this tsunami of information. The impression is that we really have a tight case against Assad and his henchmen, along with all the other players in that tragedy. And I have to tell you, we don't. We have some good evidence, but really what we have is information, and at best it's criminal information, but it's not evidence we can use in court. We need to start standardizing all of this and take all that we have out there and turn it over to proven professionals who have already done this, and create an ability to really develop a good trial package so that a year from now, 5 years from now, or 10 years from now, we can hand that evidence over for a just result. And I suggested we would call this the Syrian Accountability Center. And it would just bring in the professionals who would take all of this data that is being accumulated by various NGOs around the world and sift through it and really turn it into reliable evidence using all of the rules of procedure and evidence that we have at the international level. That got some notice and some attention, and I recall in the fall we had several meetings, and in November we decided that this was something we would want to do and began drafting an idea that we would present to the General Assembly because the Security Council is deadlocked on everything related to Syria. And we put in four corners this idea and presented it to the General Assembly, a special session of the General Assembly, just a couple days before Christmas. So there's all kinds of amazing things happening in just that alone. And 105 countries said that this is what we would like to do. Then they asked me to prepare a white paper on, well, what would this look like and how it should it be? And so I put together this white paper over the Christmas period, the holiday period, and I suggested that this would eventually be called not the Syrian Accountability Center, but a name that's about a title that's about 25 words long. We call it the Independent International Mechanism, but there's 23 other words that go with it. But that's fine. But you have they began to put it together, and now we have the terms of reference that the Secretary General signed and are now public. And currently, they're looking for to start this thing sometime in April or May. I suspect it'll be May or June. But what you'll have is a director, a deputy director, a chief of administration, and chief of investigations, who would then begin to, centered in Geneva, to begin this process of collecting all of this data and turning it into useful information. Now, this is, in my mind, the beginning of a tremendous alternative to where we're going with international justice. As I said, we have atrocities, but the political system doesn't catch up to it. Accountability centers can do this. And so the international independent mechanism is kind of a beta test as to future accountability centers where we could create them quickly and begin capturing this data, not by NGOs or using NGOs or working with NGOs, but turning this into an evidence package which, when the political decision is made to do something, and it is a political decision, then we would have this information as such that could be used in court. And I call it the Global Accountability Center system. And I've been talking to the House Foreign Affairs Committee on, they called me once and said, what's next? And I said, well, I'm glad you asked. And so I talked to them about this. And they're thinking about some things related to that. And I think we should do the same thing too. But again, the independent mechanism is the beginning of a very interesting beginning in accountability. And it's a huge step forward. I just don't think it got the notice that it should have. It's an extraordinary idea which will allow the system itself to catch up to itself and be able to take the data and turn it into something after the political will or the deadlock of the international system finally catches up to it. So be looking to the independent mechanism, the UN's first official office, permanent office that will start developing true evidence so we can take that into court.
Yeah. So, as Amy said, we came back from Iraq three weeks ago, and I speak under the authority of people who know Iraq much better than I do, and have been working on accountability options for a long time, namely Ambassador Rapp, and I don't know if Matt is here, but he certainly spent a lot more time on the ground than I did. We've been looking at Iraq and what's going on for a year, and 2 weeks, it's clear that there is a great need for accountability, and there's a great cry for justice from the victims that are now mostly in refugee camps and spread around Iraq. When we went there, it was the beginning of the Mosul operations. In this visit, it was the beginning of the Mosul operations. So we ended up not visiting as much as we would like. But the truth is that I mean, if we speak about accountability, and we know that there are a lot of initiatives going on in the Security Council. The UK has been trying to push for a special investigation, a special commission focusing on Daesh, now extended to Iraq. They didn't get the support of the Iraqis. And I think one of the reasons is also because I think there's a strong will of the Iraqis to do something, and of the Kurdish government in particular. I think if you go to Iraq, Iraq is not as, well, there's no one solution fits all. I think that's something that we know. And I think the thing with Iraq is that if we arrive, you basically find that Iraq today is holding a Iraq today is interviewing alleged perpetrators, informants, witnesses, and victims. They are being interviewed today by judicial investigators and by judges. Now, this sounds very good. It's not this simple, but basically what's happening is that with the military operations against Daesh, a lot of people have been extracted, a lot of people have been captured, they are held in prison, the prisons are full, in conditions that are inhuman, as documented extensively by Human Rights Watch. But they are being interviewed, they are being processed, namely by the intelligence officers that are not specially prepared, and they don't care specially about atrocity crimes. They are being interrogated and interviewed with very short interviews. We don't know what kind of interviews are they going through, but they are being interviews. But the interviews focus mostly on terrorism and membership and what they did as terrorists. We don't talk to them or interview them on how much time did you spend there, what did you see, where were you based, what did you do, did you see this or that. So we don't extract information that could actually be relevant to document atrocity crimes. And I mean, I think a lot of the participants are prosecutors, so we all know that it's much easier to prosecute someone for terrorism or membership of terrorist organization as opposed to crime against humanity. So, but this is something that is not being done. But these interviews are happening, and there are registers of these interviews. These people go to trial. It's a secret trial, and it takes 20 minutes. So maybe it's not a real trial, but it's a trial. And then they are sentenced, and they stay in prison, or they get the death penalty. That only has a moratorium in Kurdistan and not in the rest of Iraq. So this is being done, and this is being done with hundreds and thousands of people. So it's not that the perpetrators or informants or witnesses are not there. I mean, we know they are there. And then the Kurdish government also created the Genocide Committee that is headed by an investigative judge, appointed by the High Judicial Council. He works with 15 Iraqi police officers that have now interviewed 800 victims that came forward. These 15 policemen work with health professionals. They have 2 psychologists. So there's plenty of documentation. So we have the victims, we have the perpetrators. They don't talk to each other. So the investigative judge that is collecting the information from the victims doesn't talk with the people who are doing with terrorism, because they deal with terrorists. We do real crimes. So we don't talk to each other. And this is a problem. Now, of course, nobody really wants to do capacity building to the Asaish at this point, but we also support very little the Genocide Committee that is actually interviewing a lot of the victims and doing very, very important work. We also have a third phenomena that it's documentation. A lot of documentation, a lot of money from donors has been put into organizations that are documenting the crimes. NGOs, local NGOs, international NGOs, and, well, taking your own words, 99% of this documentation is not going to be used in court. So we do have official judiciary taking information that we are not interacting with, and we are putting money in NGOs. And then we also have CIJA who works with the Ministry of Martyrs and Unfall Affairs, that created a special investigation unit to document the crimes. Now, weirdly enough, this special unit does not have any judge, and instead of having police officers working in the unit that would automatically validate the interviews, works with people seconded by other ministries of the Kurdish government, of social affairs, that, again, document. So we are not building the capacity of the people who would have the legitimacy and the capacity and would be in a position to investigate and prosecute these crimes. We are just ticking the box of the international conscience and just putting money into documentation, just not acknowledging what the Genocide Committee is doing, and we have all these thousands of people detained and being interviewed, and we don't know what's happening with this information. I'm sure that any investigator or prosecutor would say, maybe we should sit together and see who these people are, where did they come from, what is the information coming from the victims, when were they detained. And this is what we found in Iraq. And I think there's a very strong will to do investigation, and there's plenty of documentation being done, and there's no lack of information of the crimes committed. But the truth is that, and we all want to go to the Security Council, and the UK as a great ambassador for its initiative. But maybe, rather than, we should go to Iraq and see what's happening, because these people and these judges and these policemen are Iraqis. And again, we go back to the trust issue. In the long term, it's not going to be a special commission of inquiry or a special tribunal that will sit in the Iraqi courts or in the police stations. It would be these policemen that are not trusted and are interviewing the detainees, and are these policemen who are collecting information from the victims and are providing no feedback because they don't have any feedback to provide. And if we continue to do this, the national system will not be strengthened. We need to, even if it's a big risk, and we know that a lot of unfair things are being done and there's no capacity, we need to engage with the national system. We need to, because the Iraqis are going to stay exactly where they are. And this is the people that we need to strengthen the capacity of. So I would, when people talk a lot about the Security Council, I think it's great, and I think one thing doesn't impede the other, and it's obvious that even if we have an international initiative is always being complementary to a national initiative, and the national system will never handle the really top level people. We will need an international component, but that doesn't mean that we completely ignore what's going on in Iraq today and what the Iraqis are doing. And maybe this would allow us to buy in some good political will to actually have them say, yeah, we don't mind an international tribunal or a tribunal that has international participation. So one thing doesn't preempt the other. Yes, so that's what I saw in Iraq.
Okay. Okay, I'll try to be very brief about Sudan. South Sudan, I think you're interested in South Sudan. So in terms of South Sudan, basically, I don't know how many people are aware of this, but maybe for the students in the room, there was an agreement signed under the aegis of the Intergovernmental Authority from the Great Lakes region of Africa in August of 2015. And one of the key things about that agreement, this was meant to end the conflict in South Sudan, was that it came up with a tripartite framework to deal with the aftermath. There's a question in my mind that is a predicate question whether, in fact, this agreement has held, because since then we, of course, had a number of hostilities in South Sudan, very unfortunate incidents that suggest that the conflict really never ended. But that being said, the three-part structure that they came up with, which is fascinating, included the components that we've been discussing here all day today. One is a hybrid court for South Sudan, and I don't think I'll be divulging any confidences to share that Prosecutor Jallow and I had the honor of being assisting the AU in drafting some instruments towards that direction, so the criminal hybrid court. that will be trying international as well as domestic crime. So this is in the hands of the AU, and they are working on pushing it, especially at the level of the Commission. There's a second component that dealt with Truth Commission, so it's a Truth and Reconciliation and Justice Commission, TJRC. And the idea there is, again, to kind of borrow from the best practices elsewhere, have the mass of the individuals appear before this commission. And then there's a third component that directly relates to the conversation about victims. And this is a Compensation and Reparations Authority. It's a Compensation and Reparations Authority. It was meant to be established within 6 months, and it was meant to have a compensation and reparation fund. Again, going back to Susanna about the ICC and where is the money going to come from, one of the key differences here ties into the observation I was making about the Iraq situation, where we had the $20 billion spent to address claims by Iraqis. This one is very close in model in the sense that South Sudan is supposed to come up with the resources for the Compensation and Reparation Fund. At least that's the theory anyway. Okay, whether South Sudan would bring those resources forward is a different question altogether. At this point, there was the process was meant to have some kind of the reparation fund would be part of the authority, and they'll come up with a system, and people will apply. And the idea is a laudable one, which is to say that we recognize people's lives were wrecked by the conflict that has happened in the country, and they need to be able to get some help to move on. All of these three mechanisms are in different levels of limbo, so to speak, at the moment. I think the support of the international community partners will be crucial if this is to go forward, both in terms of the hybrid court for South Sudan. I think the U.S. government was very, very favorable towards this, and I know people in the room who worked very hard to get that support. I want to kind of make that shout out. But also, of course, the European Union and other partners that have expressed a lot of interest in supporting accountability in the criminal law sense for the hybrid court, which is supposed to be an AU-led process with a mix of South Sudanese and African judges and prosecutors. I mean, really borrows from the best practices that we've seen in other settings that would then have that legitimacy and credibility, probably sitting outside of the country to begin with, maybe in a neighboring state like Tanzania that has the resources and what have you. But then, of course, in terms of the compensation authority, really being based in the country, processing what would be expected to be a large number of claims that tie into the recommendations of the Commission of Inquiry, which uncovered a desire on the part of victims for support. So we are at different levels of limbo for compensation for victims, a criminal court, and then the Truth Commission. But it is hoped that we will be able to move forward, especially once the AU's new chair settles into the position. Hopefully they'll be able to continue the dialogue that is important with the government in Juba to see the long term of all of this, that it will be in South Sudan's best interest to pursue these options, because they came directly in many ways from the recommendations of the Commission of Inquiry, which was listening to the views of different stakeholders in South Sudan, especially the civil society and the victims themselves.
All right, I think with that, I think we are allowed to go a little bit over just to take a few Q&As, and then we'll wrap up. So maybe a handful of questions. Yes.
Thank you for this. Yeah, thank you for this wonderful panel, and Anna for chairing it so ably. Really an amazing collection of experts and insights. But we do have sitting on the panel someone who more than anyone else has worked, I think, at least on the U.S. side, on the Special Criminal Court for the Central African Republic, and that's David Mandel Anthony. And I'd really love to hear from you about your work, where it stands, what your sense of the prospects are, and whether you see this as a kind of model for the future. Thank you.
Thank you, Jane. I'm glad to talk about the Carter Special Criminal Court, where it stands, and some next challenges and some lessons we might learn. Just in terms of brief background for those of you who don't know, in the spring of 2015, the national government of the Central African Republic passed national legislation creating a kind of mixed court to investigate crimes against humanity, war crimes, and genocide committed in CAR since 2003. The court, the structure of it is envisioned to be within the national system, using national laws, but with a mixed composition of personnel, with the mechanism being that the UN would recruit and nominate an international chief prosecutor, a minority of international judges at the varying levels in the French civil law system, a deputy international prosecutor and a deputy international registrar, and those internationals would be formally appointed by the national authorities. 2 years on, I think we've seen some fairly good progress with a lot of work yet to do. The three most immediate concrete steps I think I would identify for the court is they need to complete the process of appointing international personnel and national personnel. The chief international prosecutor was just named a month ago, highly esteemed military jurist from the Congo named Toussaint Montezini. The UN is currently soliciting nominations from member states for further international personnel. I speak so often to my colleagues at the State Department about the need to support the Special Criminal Court that I'm afraid some of them may have slipped in an application to second me to Bangui at some point.
He's working on it.
But finding qualified personnel is indeed a challenge, one I think that carries a lesson actually for us, all of us in this field, because this is not The Hague. And challenges on the ground are significant. And we need to deal with that. Second concrete next step the court faces is finding permanent premises. This might surprise a lot of people to refer to a court that doesn't have a court building yet, but indeed, it's been a long project to find a donor who will refurbish a courthouse that will have the adequate facilities to store records and house investigators and prosecutors and judges with adequate detention facilities for those accused. And the third will be a long-term project of securing financial support to the court. Because, as Prosecutor Crane knows, the challenges inherent in a tribunal which relies on voluntary contributions are significant, and this is one such mechanism. But three, I think, bigger political challenges and next steps for the court. One is that once there are a sort of core component of international and national staff in place, they're going to have to very quickly use the political window to demonstrate value and legitimacy to the population. In a country which has sometimes struggled to define itself as a country, much less deliver meaningful justice and recognize victims as citizens and as justice users. The challenges will be enormous, but the rewards, I think, of even a few perpetrators in the dock will be quite enormous as well. It would be a paradigmatic shift in the history of CAR for citizens to see anyone powerful or even remotely powerful being called to account. The second bigger challenge, I think, and opportunity is that the Special Criminal Court will have to demonstrate to the array of actors working to support the development of the broader rule of law system that specialized justice mechanisms focusing on atrocity crimes can have a spillover effect and can demonstrate value to the larger justice system, that this is not a satellite or a spaceship, but that in fact in the areas of developing rules of procedure and evidence, of developing real capacity to do victim and witness protection, that in developing the capacity to investigate sexual and gender-based violence, and even such routine rote things as developing record management systems and all of the nuts and bolts of a daily justice system, that this special court will be an incubator and an innovator of those practices that can then galvanize development in the broader system. And then the third and final challenge I think it faces is that it will need to not exist in isolation as a transitional justice mechanism, but it will need, as many panelists have emphasized for other contexts, a court will need to link to broader institutional reform, memorialization, and truth-telling processes, which are at a very, very inchoate stage in CAR.
Other questions? Liz. Hi, I'm Liz Evenson with Human Rights Watch, the International Justice Program. I very much appreciated all of your comments and also the emphasis, I think that was universal, about the need to better import the views of victims into these criminal processes in particular. And I just wanted to ask, what have you seen concretely that works? Sophia, you mentioned surveys, but the institution I know best, which is the ICC, it has a lot of potential channels. And Susanna, you mentioned the Article 15 process in Kenya, but each successive Article 15 process has gotten more and more emptied out of meaning. And victim participation has been kind of clarified that even if it is done more effectively, it will still only be a channel for a very small number of victims who are directly concerned by the case. Right. So concretely, have you seen from any of the other mechanisms what works, and how do you get the institutions to pay attention?
Yeah. I just have one comment that connects your question to David's comments, and it's actually, I credit David Tolbert in a recent op-ed he wrote with respect to the mechanism. And what he said was to take a victim-centered approach in that context was to interpret the mandate of this mechanism not as one to collect evidence, but as one to work with civil society groups that had already been collecting evidence for a long time and to understand it and better analyze it. So one way to sort of give voice in some ways to what civil society groups have already been doing in that context is to look at what they've gathered and bring the analytical lens to that evidence. And the other thing he mentioned was the protection of victim and witnesses in that context. So to the extent the focus is on analyzing what's there, you avoid having to connect with victims and put them and re-interview them, thereby avoiding potentially putting them at risk, at further risk. So there's ways, I think, I mean, this is obviously yet to come, so you're looking for examples that have happened, but I thought that was an interesting and really timely piece. To stay centered on, victim-centered in the process of a new mechanism. How do we do that without, or more the other side to this, right? How do we take advantage of how victims have engaged in this process already?
Outreach is still important. It will always remain important, because if you cannot connect whatever you have, whatever kind of mechanism it looks like, if you cannot connect it with the people that you're there for, then there's no reason for you to be there. In September of 2002, the outreach program was always part of my strategic plan, which I briefed at the U.S. Institute of Peace in May of 2002, saying we're going to have a thing called an outreach program, where we're going to go out and walk the countryside and just ask the people of Sierra Leone what happened. Now, I can remember the stares looking at me going, what is this guy talking about? But over the years, many years, and all my colleagues, subsequent prosecutors and the court itself kept up the outreach program because it's a direct link to the court, and it gives them a sense that you care, that there are stakeholders in this, and that and outreach is more than just walking around one time, but to constantly be up country, talking to them, asking them questions, letting them tell you how you're failing and how you're doing well. It's a process that goes on throughout the life of a court, and I think that the outreach program at the Special Court for Sierra Leone. And the neat thing about this was it wasn't just the prosecutor, but it was eventually the judges, the defense counsel, and everybody going up country, listening and talking to the people of Sierra Leone, I think paid great dividends for them because they really realized that in some way they did have a voice in the justice aspect of this international tribunal. So outreach is still very, very important, and I'm troubled that doesn't seem to be catching on, even though it has demonstrated successes. The ICC has paid lip service to it a bit. The other tribunals picked up on it a little bit, but they were already well advanced in their work. But I would just underscore that to help you with your question, whatever the mechanism is, you have to have an ability to talk to the people in the region and listen to them.
Just a quick thought, which is the observation that as international justice becomes more localized, this question of outreach and victim participation, the terrain is going to change a bit. And it's going to depend in part on the legal culture of a country. When I was working in Uganda, assisting the national prosecutor, it was sort of an alien concept for them, the idea that a prosecutor would go out to the village, sit down, explain what was going to happen in the courtroom, what the charges were, how the process worked, sort of lift the veil. And I think there's a part of this that is simply a professional culture that has not engaged in that manner before. On the other hand, moving closer to national systems sometimes offers some increased opportunities and advantages. In the civil law system, for example, victims get a right to their own representatives in proceedings. And what this has meant practically in the Habre court and in the Congo is that, and also in, I should say, in Guatemala, which retained some elements of civil law system, is that victims have a more formal role to play, and so they have to be included. And this can be used to the advantage of those who would like to see increased victim participation.
All right, I think with that, we'll close, and thank you to all our panelists for all their rich insights.
Yeah, great comments.